Good afternoon. So I propose to spend no more than 30 minutes, try and be even briefer perhaps if I can, on the tax side of things. There are some important issues here of wider relevance in this particular case, and I'll try and go light on the tax technical detail. I can synthesise that. But there are some broader points of principles which are interesting and important. So just on the procedural objection that's being taken to the Court of Appeal decision that the salary ought to be, the payment of profits reflected in the salary should be the net amount. The claimants take objection to that on procedural grounds. First point to note is that this was pleaded in the High Court in the High Court proceedings, and the reference to that is E489, and it's paragraph 24E.
Thank you.
And it's at the very bottom of page 489, where the defendants assert that they had to pay tax on the salaries and only received the benefit of the figures net of tax. So this is a point that was pleaded. The only defence to that is at 497, or the only response to that is at 497, lifestyle paragraph 14A sub E, page 497, said that it's down to the defendants to prove that these were salary, and they haven't provided any evidence of that. And that's not as I understand it, as one can see from the decisions, it's not a point that was pursued in the actual proceedings. So it's accepted that these amounts were salary. So the point raised by Lord Justice Burse in the Court of Appeal does not go beyond the ambit of the pleadings. It was open to Lifestyle in the High Court proceedings to put in any evidence they wish as to these amounts of salary. But as it turns out, the actual amounts of salary and the tax deducted are not in dispute. That's recorded by Lord Justice Burse in the Court of Appeal judgment. There's no dispute as to the figures. Furthermore, it's a question of law that employment income is taxable on a recipient. There's really very little fact involved in that. So, in my submission, it was open to the Court of Appeal to raise this point. It was a point covered by the pleadings at first instance, although it had been overlooked in the actual decision. What's more, it was a point, the tax point was related to the issues pleaded on appeal, in particular ground 5, which is at 580. These were the grounds of appeal before the Court of Appeal. Ground 5, page 580, paragraph 6, deals with the deductions that could be taken from salary. And the assertion there is that the ground of appeal is that the judge erred in law in holding that there were no costs that could be deducted and that nothing fell to be deducted. Now, it doesn't expressly deal with tax, but it's broad enough to cover that, particularly in light of the fact that tax had been pleaded at first instance. Further, to ignore tax, and this must have been a consideration which the Court of Appeal had in its mind, to ignore tax would give rise to a punitive result in that the Ahmeds would be obliged to pay amounts which didn't reflect their profits at all or their receipts at all, but way beyond that. and the effect of that would be punitive. And clearly, if the court is minded to exercise its discretion to order an account of profits, it needs to be clear that it's not going to have a punitive effect, an obviously punitive effect, if an obvious consideration such as tax is not taken into account. So in my submission, there's no procedural objection that can be taken to the Court of Appeal raising this point. In terms of the substance, the numbers are at page 701, which is a schedule that was in evidence before the Court of Appeal that sets out the salary net and gross. And the judgment amount, if your lordships can see at the bottom of each table, there's a judgment amount less 10% tax NI amount to pay. So the 78,939 for Mr. Ahmed, and then for Miss Ahmed the 38,830. Those are the amounts that are actually reflected in the Court of Appeal's order.
Well, how does the judgment amount doesn't seem to correlate with the total salary?
I'm sorry, my lord?
The judgment amount doesn't... where does the judgment amount come from?
Well,
it doesn't correspond to the total
I believe that may be the 10%. I believe it may be the 10%. I'll need to...
Less 10% tax. Oh, I see. But it's not 10%. I mean, 10% is an easy figure to calculate.
Yes. I'll come back on that. But those are the amounts that were
the tax
subject.
It's only 10% of the total.
Explain it later. Yeah. So the amount that's in the order is 78,939 and 38,830. What is asserted, and there's no challenge to that, the quantification exercise, what's asserted is that it should be the gross amount, the 144,192 and the 57,007, which are the amounts also set out there. And it's of note that the years, the tax years, so each row corresponds to a tax year. So the first row is the tax year ended 5th of April 2011, etc. So the payments of salary span a number of tax years, and that's relevant when it comes to the mechanics of a tax refund or deduction. And turning over the page, 702, and there's a number of these P60s, that actually shows that the amounts were received subject to deduction of tax. So the schedule simply picks up these P60s. So the amounts were received net of tax. And the question is whether it's the 144 or the 78 in the case of Mr. Ahmed, or the 57 or the 38 in the case of Miss Ahmed. Now, Lifestyle's position is that it's the gross amount of the salary, the 144 and the 57,000, that need to be paid irrespective of whether the Ahmeds are entitled to a deduction for any payment they're ordered to make. They say it's irrelevant whether you can receive tax relief for the payment that you're ordered to make or not. We want the gross. And they say that at paragraph 95 of their appeal, which is at page 287 of the electronic bundle, or page 170 of the key documents bundle. They say Lifestyle's position is that even if these avenues did not exist, that's the avenues for deductibility or a refund, the Court of Appeal got the law wrong because the deduction of tax paid by the defendant from the account he is required to make to the claimant penalises the claimant for the defendant's wrongdoing and defeats, or in part defeats, the object of the account of profits. And we submit that this is clearly wrong, and that the proper principle is this: where a payment is determined by reference to the claimant's loss, then tax payable by the defendant is generally not taken into account. And there's an exception, which is called the Gawley exception. But generally speaking, it's of no concern to anyone that the defendant has paid tax on the amount that he's effectively having to pay over to the claimant, because the award is by reference to the claimant's loss. However, where the payment operates by reference to the defendant's profits, as in an account of profits, then it is necessary to take into account the actual amount, post-tax amount received by the defendant. And that's based on principle, and it's reflected in the authorities. Contrary to what you've heard before lunch, there is no conflict in the authorities. They all say exactly the same thing.
But this is your submissions would relate to a relatively straightforward case where the money is paid over and income tax is paid. But I mean, it's possible to imagine circumstances where the person receiving the money gets a tax benefit or
Indeed,
uses it in a tax-efficient way. And
Indeed, my lord. So there's two steps, and indeed this is the approach that was adopted in the Celanese case by Mr. Justice Laddie. The first step is to say, well, you look at the net receipt, and those are the profits that one has to account for. And then there's a secondary question. Well, is the defendant going to get a refund or a reclaim? In which case, that may affect the amount that's ordered to be paid. But those are two separate stages. And that follows from the principle that the purpose of an account is not to punish a defendant, but to ensure that he does not just unjustly enrich himself at the expense of the plaintiff. And that is obvious, but it's a quote from Mr. Justice Laddie in relation to tax in the Celanese case at E1305. And because I'd like to short-circuit all of these cases, I'd like to just refer to Celanese, because it actually deals with all of these cases. And if your lordships would like me to take you to the actual cases that are referred to, I can do that. But everything is set out very succinctly by Mr. Justice Laddie.
There's been no more recent authority.
I haven't found more recent authority, my lord. Not on this point. This is the most recent case in the authorities bundle, and hence it deals with John and James and O'Sullivan, and is the most useful. So it's at page 1305, paragraph 129. Mr. Justice Laddie states, therefore, that principle, that it's not about punishing, but about preventing unjust enrichment. And then he says, third line down, if the defendant has paid tax on the profits, then subject to the question of what happens if he seeks and obtains a tax credit or repayment, the benefit to him is the sum he retains after tax. So that's the second stage. And that's my submission, logical and principled, because tax is an expense like any other. And if one is going to draw a sharp dividing line between tax and any other expense, then what tax is one going to treat in this special way? Employers' national insurance, irrecoverable VAT, business rates, these are all taxes, and they all uncontrovertibly fall to be taken into account. There's no difference between those taxes and, in this case, corporation tax on profits, in the Ahmed's case, income tax on employment income. And indeed, that point is reflected in the authorities, which are carefully summarised by Mr. Justice Laddie. So O'Sullivan is the case that's cited at paragraph 129 and 130, and this was a case involving an account of profits. And if I could just invite your lordships to read paragraphs 129 and 130. So Mr. Justice Laddie derives support from his view that it's the starting point is the net of tax amount on the Court of Appeal decision, also an account of profits case, which came to the same view. Now, the claimants in this case rely on John and James, but that's also dealt with by Mr. Justice Laddie at paragraphs 133, 134 and 135. And in a moment I'll invite your lordships to read that, but key part of that is to acknowledge that this is not an account of profits case. This is a compensation case where the defendants were obliged to pay over what they should have paid over. Not what they did receive, but what they should have paid over to the claimants. So that's why their own tax position was irrelevant. So that's at paragraphs 134 and 135. And in my submission, Mr. Justice Laddie says all there is to say on this. I'll just make a few points without taking your lordships to the authorities because I'm conscious of time. The claimants also rely on Bartlett and Barclays Bank, where tax payable by the defendant was ignored, just to flag this too is a compensation for loss case rather than an account of profits. As can be seen from E1227. The Gawley case is mentioned by the claimants. In this case, this is a qualification to the compensation for loss line of cases. It's not relevant at all to the account of profits cases. In effect, it says if the recipient is to be made good for what it should have received, and it would have paid tax on the amount that it should have received, but isn't going to pay tax on what it is going to be received as compensation, then the defendant can pay a reduced amount. But it's nothing to do with this case at all. The extract from Lewin that you were referred to, that's talking about tax on the recipient. It's not looking at tax paid by the defendant, so it's irrelevant to this as well. In the end, my learned friend didn't take you to that, but it's not a relevant point. So the two cases dealing with accounts of profits are Celanese and O'Sullivan, Court of Appeal and High Court, and they say look at the net. Now, the second stage is to work out what is the position of the defendant. If the defendant is able to recover some of the tax that was paid on the receipt that the defendant now has to account for, then it's fair enough to say, well, that reduces, that tax repayment should be taken into account. Now, there is very limited scope for deduction on these facts. The grounds relied on by the...
Sorry for interrupting. Yes. Before going into that as a legal issue, as a matter of fact, have either of the appellants applied for a deduction?
No, my lord, they haven't. And the reason that they simply haven't, the reason for that is the only basis for relief in this case is on a paid basis. So normally, if one is dealing with corporation tax, it's enough that there is an accounting expense to get relief. Here it's actually and the same would be true for traders subject to income tax. Here, it's employment income. The rules, because of the oddity that salary is being treated as a profit, the only relief that's available is on a paid basis. So until there's been a payment, and there hasn't been a payment, there can't be any relief.
That's a payment of salary? Or
payment pursuant to a court order to the claimants. So tax has been received net over a number of years. If the court orders a payment to be made, then there is the possibility of relief. However, in this case, and I'll come on to the details of that. There are some complications, but actually the issues are quite binary in this case. Lifestyle says pay over the whole amount, ignore your tax position, Ahmed's, and we say, well, no, that's not what the cases say, and we simply say no. In a different case, it might be that a particular kind of order would need to be crafted to suit the complexities of tax, but Lifestyle is simply asking for everything with no compensation mechanism to reflect what happens to be repaid to the Ahmeds. They want everything, and we say no. They cite Section 33, which is a Taxes Management Act, which is a provision that is used for taxpayers to reclaim tax that has been overpaid. And I won't take you through the intricacies of that because it's in the reply, but one can see that it's about tax overpaid from page 1098 of the authorities bundle, because Section 33 is entitled Recovery of Overpaid Tax. And
sorry, I think I got the wrong page there.
It's 1098.
Sorry, it was mine.
Of the electronic.
Yes, I got that.
And this is about tax overpaid. Now, it is the case that in the 2 or 3 of the cases that are before your lordships, Section 33 is mentioned, including Celanese, including John and James, O'Sullivan and John and James. Now, the reason, and the court notes that actually under Section 33 one can only go back 6 years in any event, but the possibility, obviously the revenue isn't a party to any of these cases, but the possibility that a refund could be obtained is mooted. Now, that is because those cases, O'Sullivan and John and James, involve a breach of fiduciary duty, where it can be said, plausibly be said to HMRC, that the profits never belonged to the defendant. But in this case, the account of profits is a personal obligation on the Ahmeds. And in my submission, there is no question of saying to HMRC, they never received this salary and therefore overpaid tax. Of course they received the salary. The fact that they have a corresponding obligation to pay an amount under a court order many years later doesn't remove that prior liability. So Section 33 has got no application to these facts. And indeed, in the Celanese case, Mr. Justice Laddie, because Section 33 was mooted to him by counsel for the claimants, mooted that HMRC may not agree with this, and he was not minded to reflect the possibility, let's call it that, impossibility in my submission of a refund from HMRC. In any event, there is a 4-year time limit, which means that it is only the last 4 tax years, tax paid in respect of the last 4 tax years that can be claimed. So in this case, because we are in 2022-2023, the latest year is 2017-2018, which is a year which is the final year in that table. The 4-year time limit was 6 years, so your lordships may see 6 years referred to in those cases in the context of section 33. That was changed to 4 years, and the 4 years you can see at E1104. That's the one bit of section 33 and the corresponding schedule 1AB, that I'll show your lordships. That's paragraph 3 and paragraph 3.1. A claim under this schedule may not be made more than 4 years after the end of the relevant tax year. That's the tax year in respect of which the tax was paid. So there is no, or very little, well, there's no, in fact, a possibility of invoking section 33. Quite apart from the time limits, it's inapplicable. Tax was properly paid on the salary. Lifestyle then says, well, you have an alternative route, and this is what they put before the Court of Appeal. They say you're traders, and they cite a passage from Coppinger and Scone, which is cited in the judgment, and the Court of Appeal rightly dismisses that because they're not traders, they're employees, directors treated as employees for tax purposes. They are not carrying on a trade, and the Court of Appeal rightly disregarded that avenue of relief. The only basis, and this is work that the Ahmeds have done pursuant to their duty to the court, our duty to the court, is to identify the only provision that's available is section 555, which is about liabilities connected to the employment that arise after the employment. And there are two limitations on that. I'll be extremely brief on this. The statute is at 1152. And section 555 sub 2 makes it clear that the deductible payment may be made for the tax year in which the payment is made. So in other words, if a payment were ordered to be made before 5th of April, then it can be offset against the income for this year, 2022-2023. There is a cap which...
Well, they're not still employed, though, are they?
They're not still employed,
So,
indeed, but this provision is aimed at that situation. So it allows a deduction against other...
Oh, previous employment.
No, because that ceased. Other income.
Oh, any income.
Any income of the year. Any income of the year. Now, but that obviously depends on that income being sufficient to absorb it. And the other limitation, before I take you to the income, levels of income that we're talking about, is 1162, which is a limitation on this deduction, and it's section 24A sub 2. The amount can't exceed 50,000. Well, that's going to be the relevant limitation here. So the amount that Lifestyle say is due from Mr. Ahmed is 175,000. Only 50,000 of that would be deductible, assuming he has 50,000 of income. Miss Ahmed would not have this problem, but again, we'd be limited to her income. Now, the evidence before the Court of Appeal as to current income, and I'll give your lordships the references, Mr. Ahmed was earning, the reference is E806, approximately 32,760 per annum. And Miss Ahmed, 8,628. The reference for that is E854. So E806, E854. So those amounts are considerably less than the 144,000 and 54,000, which correspond to the gross amount received over the number of years that are reflected in the payment order.
So page 806.
806 and 854.
So on 806, we see you're referring.
Yes.
You're referring to
the income there.
Income.
Yes. So that's the 13,650, and if you multiply that up.
Oh, I see.
Yes. I'm sorry. I should have said that. This is actually the subject of a witness in both cases. In the preceding pages, there is a witness statement explaining that.
So let's say in the case of Mr. Ahmed, if he was still earning 32,000 in the relevant year, he could claim a credit of all the tax he paid on that income, could he?
No, he could deduct 32,000, and get the reclaim of the tax on the 32,000. Yes.
So he'd be claiming back the tax he paid for that year.
For that year, that's right, my lord, and that's all. And he couldn't take it forward, couldn't carry it back. That's all. So, in my submission, your lordships are faced with a binary choice here, whether to take into account, whether to uphold the Court of Appeal's decision, which we say is correct, which is that it's the net amount, or to go with Lifestyle's proposed order, which is it's the gross amount. In another case, it might be appropriate to fashion a form of order that reflects the relief. Mr. Justice Laddie's order was quite limited in that respect. He said, well, if you get the tax back, then fine, but you're not under any obligation to claim the tax back because I can see there's bad blood, and this is going to cause even more litigation. In this case, there are complications because aside from the fact that no one is asking for a qualified form of order, relief is on a paid basis. So the effect of the order will be to make a payment. That will give rise to a tax refund. If the order then says, well, that tax refund gets paid over, then that gives rise to another refund, and one ends up in an iterative. Now, that fortunately is not the decision that your lordships have to make because it's a binary case. But in my submission, it would be quite wrong, given the limited relief that the Ahmeds may obtain for these payments, for them to be made to pay gross as requested by Lifestyle.
What happens to the tax position if the profits are disgorged and are received by Lifestyle? Do they have to pay taxes?
They have to pay tax. They have to pay tax, yes.
Yeah.
In an ordinary case, where it was the company paying its profits over, the company would get a deduction for the amount that it paid and could carry it back and would get a tax refund. Lifestyle would pay tax on the amount that it received as compensation, but because of the refund to the company, would get an additional amount. The issue here arises because the payment is being ordered by reference to salary, for which there is limited ability to deduct. And that is a feature of the oddity that in this case, salary is being treated as a profit.
So on the facts of this case, HM, Customs and Excise get paid tax twice.
Yes, my lord, that's right.
On the same earnings.
That's right, because it's salary that's the focus of the account of profit. As I can assist your lordships further, those are my submissions on tax.
Thank you, Mr. Sykes.
That's fine.
My Lords, on the first ground of Lifestyle's appeal, I hope I can take this relatively shortly. We deal with it at some length in our written case, and we set out what all... Oh, yes. Yes. Apologies, my Lords. On Lifestyle's first ground of appeal, and I hope I can take this relatively quickly, we do set out our case in some detail in answer. We go through all the cases sequentially. But what we say is this. A cannot be compelled to account for B, for profits received only by B. In particular, a director of a company cannot be so compelled when the profits have been received only by the company, save perhaps where the company is a sham and can properly be regarded as his agent. And the Court of Appeal was therefore right in applying the principles it did. Secondly, and in any event, an account is a discretionary equitable remedy. And on the facts of this case, it would be wrong in principle, or at least wholly inequitable, to order such an account for the reasons I've already gone through in our own appeal. That is no allegation of dishonesty or even of lack of reasonable care, and no allegation they were acting other than as directors or employees.
Well, presumably the point you're making on this submission, though, is that it would be wrong as a matter of discretion to order them to pay out profits that they haven't received.
Absolutely. That's the basic point. But especially as, my lords, there are authorities that suggest that there may be cases. Can I give you an example? Two people go and rob a bank. Well, they've done one thing that's wrong automatically, that is rob the bank. But they put the money into a joint bag, they get back home, and then they divide the bag up. Now, you might say they might have a fit of conscience and then take it back to the bank, which is what they ought to do, but they don't. They divide it up between the two of them, half each. Now, in that sense, you can see there is room for saying that each should account for his own £100,000, which, by way of quote, an account of profits, you can see that. But then, equally, each has done a further wrong as against the bank, which is, at the division of proceeds point, give over or allow half to go to his confederate. And so you can see in those circumstances that where there is what you might call a conspiracy or an acting in concert, there is room effectively for ordering an account of profits of what you actually keep yourself, and equitable compensation or damages for whatever it is, wrongful conspiracy, for what you then, that portion of the money you have in your hands, which you then hand over to your confederate.
That's a sort of a channeling point.
Sorry?
The channeling point, is it put
Yes, a channeling point, yes. So you could see how in that case, but strictly what would be being ordered would be an account of profits of 100,000 and damages or equitable compensation for the other 100,000 for your further wrong at the moment of dividing up the proceeds. And my lords, that I do. When you look at the fraud cases, you can see that obviously there's a temptation for the courts to say, well, I'm going to treat you, Mr. X, so to speak, as having received all of this, because you did at one point have it all in your control. The fact you went and gave half of it away later is irrelevant. But those are totally different types of cases. But I say the general principle is you are liable only for what you yourself have received into your own hands.
The example you give is a combination of account of profits and also damages.
That's right, exactly.
And after an election, can you get that?
Well, you elect the claimant, as where the bank says to A, I'll take the £100,000 you've got in your hands by way of an account of profits for your original first wrong, that's robbing the bank. And then, as to the other 100,000, well, that's a separate wrong, and I want compensation for that separate wrong. It so happens it's the money you handed over to your confederate. But in my submission, that's a perfectly simple way of getting to that result. When you have these people acting in concert who receive into their hands a joint sum of money and then divide it up, the reality is they're committing a whole series of wrongs. And you can, in my submission, order an account of profit for one wrong and then order, if there's a separate wrong, damages or an equitable compensation for that separate wrong.
Yes, I was thinking Cook and Deeks, though, isn't like that, because it wasn't a question of taking money from the company. They made the profit. It's not analogous to your bank robbery case, I think.
No. Well, we don't quite know what happened in Cook and Deeks. It's unclear from the Privy Council's decision whether it was an order that each account for his own profit or that, so to speak, each account for the whole profits. We don't know. It's not apparent. But again, the point wasn't argued. I mean, one of the problems you have in this case is you're dealing with so many points which have only half been argued, or it's quite difficult to work out what was argued for the relevant courts. But I'll come briefly to Cook and Deeks in a moment. Now, I submit the Court of Appeal's judgment one of the points the Court of Appeal I especially rely on is the conceptual problems that can arise if one could make an accessory liable where he and the principal have made distinct profits. This is a point they make, I think, at paragraph 18, 17 and 18, at 343, 344. What happens then? It would make no sense to say that the victim could have only the principal's profits, or to say that he could have the profits of both, or to say that you have to elect between the two.
So you gave us a reference in the court.
I think it's it begins at 343, it's paragraph 17 and 18, I think.
17 and 18, okay, thanks. Right.
So the basic point is if it could be either the company's profits or the individual's profits, how do you decide which?
Quite. Yeah. It results in an illogicality and conceptual problems, I think is the way they put it. My Lords, my reply to what you might call Lifestyle's general submission is this. What they say is, well, surely the approach should be similar in an account of profits as it is in damages. We say the short answer to that is there are two completely different conceptual bases. Damages are awarded on the basis that you object and you continue to object to what the defendant has done, and you claim for your own losses resulting from that. And those losses might well be continuing into the future. An account of profits, or rather the premise of an account of profits, is that the claimant is, quote, waiving the tort and taking advantage of it for his own benefit. And you get that from the House of Lords decision in Nielsen and Betts, which is at 3544.
How does that sit with an injunction? Because you could get an injunction. You wouldn't be waiving anything then at that stage.
No.
So you can get an account of profits for your past loss.
Yes, you can.
Wouldn't be waiving the tort.
Well, you're waiving the torts in relation to the past. But that is how it is put. And if I can the quote is, the two things are hardly reconcilable. For if you take an account of profits, you condone the infringement.
This is page 3.
Page 3544 in Nielsen and Betts.
I'm awfully sorry.
I think it should be 3544.
Which bundle are we in?
Oh, it'll be Supplementary Authorities bundle.
Oh, right.
3544.
No, it's the main bundle.
It's the main bundle.
It's the main
3544. Okay. 3544. Right.
Whereabouts on the page?
I've got a reference, forgive me if it's wrong. I think there's more than one Nielsen. I think it's 3544.
Yeah. Second paragraph.
Yes.
Yes, right. Okay.
In the judgment of Lord Westbury.
You condone the infringement.
Yeah. That's the idea.
Well, that's one conception of waiver of tort.
Yes.
But the other interpretation of it is it simply means you're waiving the tort in the sense you're electing
Yes.
what to choose, account of profits rather than damages for loss.
Yes.
Doesn't mean you're saying that what was done wasn't wrong.
Oh, no, I agree with that. Obviously not. But
Not condoning in that sense.
No, not in that. But what you're effectively is a different. You're basically saying I will settle for the monies you've received, and I won't ask for damages. That's the essence of it. Now I say that's important in this case because if, let us say, in this case, the Lifestyle had received from, let's say, Mr. Ahmed, £400,000, but not the balance of any judgment. They couldn't go after Miss Ahmed for £100,000 because Miss Ahmed would say, well, you made an election to treat each of us as running your business on your account, and you've taken your money from him. You can't ask me to sub the shortfall or make good the shortfall. And that, in my submission, is how it obviously is meant to work.
So if you elect, and in the exercise of discretion, the court says, oh, I'm terribly sorry, we're not going to give you an account of profits. And are you left remedialess?
Well, if you've already made the election,
Well, that's...
but assume you have, well, my understanding is once you've made the election, that is that.
So that you're locked out from any
You may be.
compensation?
But we don't have to. The election doesn't have to be till judgment, does it?
Well,
I thought those United Bank or something case.
Well, principal and agent cases, certainly.
Yeah.
I can't claim to have sufficient knowledge of whether you can, as it were, run both cases to trial and to see which you get more.
I think you can.
I don't see why you shouldn't.
I think you could do that until, well, yes. I mean, you wouldn't expect the whole machinery of an account to be engaged until the election. But I mean, the reality probably would be there would be a sort of debate with the judge, and he'd say, well, I don't think I'm going to order you an account.
Yes.
And so, well, I'll elect for damages, please.
You normally have a two-stage process anyway.
Yes. You would normally.
So you wouldn't be put in the position, my Lord Stevens would, in practice. My Lords, the second reason I say that A cannot be ordered to pay profits received by B is this. The discretion to order an account is based upon equitable considerations. And its underlying purpose is to deprive the recipient of his, quote, unjust enrichment. Unjust enrichment is at the foundation of this. And, my Lords, there are two judgments. My Lord Justice Kitchen, when he was in the Court of Appeal, or one judgment in the case of Hollister, which is at 1421. 1421.
Thank you.
Page 55. Paragraph 55. My Lords, it begins alternatively. If I could just ask you to read that yourselves. And you'll see it's essentially discretionary, but it can be refused in the case of an entirely innocent infringer and so forth. But the purpose is different from damages. And then also, to similar effect, what you see at paragraph 69, where Lord Justice Kitchen was considering the same question but against the principles of European law. And you'll see paragraph 69 dealing with the question of proportionality. An account of profits doesn't compensate the trademark owner for the losses he suffered. It simply deprives the infringer of the profits he's made from an activity in which he should never have engaged, and therefore ensures that he doesn't benefit from his wrong, but it contains no element of punishment. Moreover, an equitable remedy may be refused if it would produce an unjust result. And, my Lords, bearing in mind that this remedy contains no element of punishment, I submit it is extremely difficult to see, in any normal circumstance, how A could be made to account for profits made by B. As far as the cases go, could I just ask you please to look at Grimaldi, which is a judgment, I think, of the High Court, or maybe one of the federal courts of Australia, given, I think, by Mr. Justice Finn, who was the author of the famous book. And he takes the opportunity to lay down the law in relation to various equitable principles. And what had happened in this case is that a company called Chameleon Mining had bought a number of claims against Mr. Grimaldi, to the effect that in breach of fiduciary duty he'd made unauthorised profits with the knowing assistance of a company called Murchison Metals Limited. And the claimant contended that as a knowing assistant, Murchison was jointly liable with Mr. Grimaldi to account for the latter's profits. A judge held Murchison, the assistant, not guilty of knowing assistance because it was itself a victim of Grimaldi's fraud. But they then considered the law in some considerable detail, having reviewed it in some considerable detail, and in my submission on this point it's a useful judgment to look at. The relevant passage I want to pick up is at 2026 at 557. And what the court is doing at this point is setting out the principles in relation to remedies for knowing assistance. And at 557, it sets out the general rule. If I can just ask you to read 557, I don't ask you to read the passage from Michael Wilson and Partners, but just the main part of 557. This is principle number 3, according to the court. And then if you ignore the subtext from Michael Wilson and go over the page to 2027, you'll see there's reference to various other authorities to the same effect. But then going right near to the end, it refers to a further case in United States Surgical Corporation and Hospital Products, McClellan J. I think this is a Canadian case. These are Canadian cases. A person who knowingly participates in a breach of fiduciary duty by another may be both liable to account to the beneficiary for any benefit he's received as a result of such participation, and 2, jointly liable with the fiduciary duty in respect of any pecuniary liability of fiduciary duty. And then they continue, if this is to be taken as suggesting that the liability for profits is joint and several, we disagree. I'm not sure that is what it meant, but anyway, they're basically saying you want A is not to be taken to be jointly liable for the profits of B. There may be other ways of getting to the same result, but that's a very different question. And it goes on also, and you'll see it having disapproved this, the same disapproval is reaffirmed, I won't take you to it, at paragraph 748 in this judgment, where they basically repeat the point. I think for your note, it's at 2043. So that is the general principle, and I say that's obviously correct. The next, however, they go on to say, at page 2027, 558, that there may be an exception. If I can ask you, please, to just read down to the word purposes in 558. My Lords, I submit one can see that there may be some such exception, although I submit the way one explains the joint participation where there's fraud is what I call the multiple wrongs theory, which I tried to explain at the beginning of my reply. It is likely that you have, these cases all concern people acting in concert, dishonest breach of trust. I mean, they're the lowest of the low, if I can put it that way.
It's also quite tentative.
Yes.
They say we needn't explore the matter further, it doesn't arise. They note Mr. Justice Lewison's criticism in ultra frame, and so on. Exactly.
So, my Lords, I submit that the law is, in fact, as Mr. Justice Lewison, as he then was, sets out in ultra frame, but this is a useful summary of all the different points of view. The very furthest it goes is there may be a limited exception in cases of fraudulently acting in concert to breach of trust and things of that nature. Now, Lifestyle relies on the House of Spring Gardens case. My Lords, I don't propose to deal with that at length. We deal with that in our case at paragraphs 28 to 34, which is page 182 of the key bundle, or 298 of the big core bundle. And the short point there is that the director or the people who were made to account had behaved really disgracefully. They had secretly, covertly diverted effectively a contractual opportunity, or rather information, to make, well, I start again. They had a contract with a Libyan company under which they were to provide, I think, vests of a certain type, but they would have to pay royalties under that contract. So what they decided to do is to do exactly the same thing, but I think to a Libyan company. They decided to enter into a different contract with another party where they do exactly the same thing, selling the same shirts, but so as to avoid having to pay the royalties. And they all put their heads together to come up with that fraudulent conspiracy. That's the essence of it. And that's what we set out in that part of the our case. And again, we say it's a very similar point. You've got people behaving together disgracefully and putting their heads together so it seems that they can be said to be receiving, at least in some sense, or the company they control can be said to be receiving the proceeds or the fruits of the crime. And, my lords, I submit one can easily see that in those circumstances that it may be, by one means or another, that they should each be made liable for the full loss, rather than just each for his own individual share of the profits. The other point I would mention in that is that Mr. Justice Costello arrives at that conclusion without any argument or debate. He just asserts the point. So again, I submit it doesn't tell you anything about what the general principle should be. As far as the cases on breach of fiduciary duty are concerned, I say that Ultraframe is correct. My lords, my learned friend Mr. St. Quintin took you to Mr. Justice Lewison's analysis of Ultraframe, in Ultraframe. I mean, essentially, Mr. Justice Lewison bases his analysis to the effect that there is no possibility of ordering an account of B's profits against A on the basis of his analysis of Regan and Gulliver. And we deal with this at paragraphs 38 to 42 of our case in reply. My lords, the essential point which...
What's the page number?
Forgive me, my lords, I don't have it to hand.
Not to worry.
Oh, it's 301 of the core bundle.
Thank you.
My lords, the essential point there was that there was one director, Mr. Gulliver, who was not made liable for taking part in the plan by which an opportunity was used by the directors and by which they invested in a subsidiary company. So he alone is let off. All the other directors are made to account for their profits. But the essential point in that case was that Mr. Gulliver, who appears to be responsible for the decision by the board to invest in the subsidiary, he was held not to be liable because the only profit he made was a profit through a subsidiary, which had never actually distributed the profit. So the House of Lords held, well, you haven't received any profit. He hasn't received any profit. And therefore, that being the case, he was off the hook. But the more important point, which Mr. Justice Lewison points out, is he wasn't ordered to be liable for the other co-directors' breaches of duty. Now, in that case, I should say, there was no allegation of dishonesty or anything like that. It was put against the directors that they had put themselves in a position of conflict, and it was for that reason alone that they were ordered each to disgorge his own profits. And Mr. Justice Lewison's analysis was that that doesn't matter. That was not the crucial point. And he gives his reasons in his judgment, which we say are correct. But we also say, for the purpose of this case, you don't have to resolve this dispute, because this is not a case, that is to say, the dispute between Mr. Justice Lewison and Mr. Justice Lawrence Collins as to what is the right approach where you have fraud. I think Mr. Justice Collins's point would be, well, Regan and Gulliver can be explained on the basis there was no fraud, so each is liable only for his own profit. Whereas in the CMS Dolphins case, well, there was a plain fraud by the defendant, and what he had done is put the business opportunity and then all the proceeds into a partnership of which he was a partner. Well, you can understand in that latter circumstance, where there's manifest dishonesty and he's controlled, so to speak, the profit line, that there may be a different result. But, my lords, I submit, I can't possibly deal with that now, but there is that dispute between Mr. Justice Lewison and Mr. Justice Lawrence Collins as to whether, effectively, serial dishonesty, taken together with complete control over the opportunity before the proceeds come in, makes a difference. My lord, there is one case which I submit is important on this issue, and that is Imperial Mercantile Credit v. Coleman, which we deal with in our case in the key bundle at page 185, paragraph 43 onwards. And if I can just give you if I can just ask you to go, please, to page 3324. Just to set the scene, what happened in this case was that Mr. Coleman was a stockbroker with his own business partnership, but he was also director of Imperial Mercantile. And what he does is he arranges for his own stockbroking firm to have a 5% commission for placing certain debentures, and then he proposes to the company that it should likewise place the same debentures at a commission of 1.5%. And which the company duly does, and he doesn't properly disclose his own interest in the transaction. The effect of that was that whenever the company placed various debentures, the company got 1.5% commission, and his firm got the other 3.5% without the company's knowing it. So it's not great facts. And the decision was that Mr. Coleman had to account for all 5%. In other words, the difference between 1.5% and 5%. Now, this was called an account of profits, but in my respectful submission, the logic of actually what their lordship said was you diverted this opportunity to get 5% from the company to yourself. Therefore, you must compensate the company in the difference between the 1.5% and 5%. Now, my lords, one of the difficulties with this phrase account of profits is it can be used in different ways. You can well see that equitable compensation could be ordered on the footing you must pay over the profits you've made, because they should strictly have been made on behalf of the company rather than going into your own pockets. But when you look at the reasoning, can I ask you to look at the reasoning? You'll find what Lord Chelmsford says at 3326 in the passage beginning, the liability of partners. Who are implicated, and so forth. 3326.
My
lord, I don't have.
Well, it's in the penultimate paragraph, about halfway through.
Okay, thank you.
The sentence, or no, 3 lines down. The sentence actually begins, but.
Yes. Thank you. Yes.
Oh, yes. Sort of seems to turn on a point of partnership.
Well, it does. It seems to turn partly on that, but also 3326 is the diverting the money which belonged to the association. So they're treating this as a case where he's, so to speak, got the money in his hands, all the 5% in his hands, and he's diverted the 5% from the company to himself and left the company with just 1.5%, so to speak. But that is the explanation. He has wrongfully diverted the opportunity. He's wrongfully diverted the money, as they put it there, which belonged to the company. So you can understand that line of reasoning. That is more in the nature of an equitable compensation. You cough up for the profit you should have made for the company, which is a rather different notion from what we're involved in here. And then, likewise, I think at Lord Cairns's judgment at 3332, again, he's not really talking about an account of profits when you look at the logic of it. 332, I think it's the second paragraph. My lords, I think there is no foundation for the argument. Can I just ask you to read that paragraph? So he's treating the position there as analogous to that of a trustee who, without authority, charges a trust. He's not really talking in terms of accounts of profits here. He's talking in terms more of, well, Mr. Coleman did the wrong thing, so he's got to pay up for doing so. But there's not an attempt to trace, so to speak, the profit he made on the footing that he has unlawfully made profits. It's more, you diverted this profit opportunity to make profits from the company to yourself, so you've just got to pay the company back. Full stop.
Well, he seems to proceed on the basis that it was Mr. Coleman's profit which he decided to share with the firm.
Yes, well, that's another way of looking at it, yes. But I submit this is not exactly talking about the language of an account of profits pure, if I can put it that way. So I say this doesn't help on this, in this case. It's certainly not authorities that A can be made to account for the profits made by B. Unless, of course, it can be said that A is responsible for B making those profits, and therefore he's got to pay, by way of equitable compensation, a sum equivalent to those profits. My Lord, the next case was Cook and Deeks, which is at 2738. My Lord, the first point is this. It is unclear, as I mentioned earlier, quite what the order was, which I think you see at 2749. We don't know whether it was joint and several, whether there was any argument about it, or anything like that at all. And you might find that there was no submission to the effect it should be joint and several. I mean, perhaps the directors disagreed amongst themselves. One just doesn't know. It's 7 lines down. It follows that, and so forth. But the other point is that this, again, was a case of palpable dishonesty by people acting in concert. And you can pick that up from 2746. I just take it from their lordships, 5 lines, 6 lines down. Their lordships think the statement of the trial judge upon this point is well founded when he said, it's hard to resist the inference that Mr. Hines was careful to avoid anything which would waken Mr. Cook, that's the plaintiff, from his fancied security. And again, that the sole and only object on the part of the defendants was to get rid of a business associate whom they deemed, and I think rightly deemed, unsatisfactory from a business standpoint. In other words, they intentionally concealed all circumstances relating to their negotiations until a point had been reached when the whole arrangement had been concluded in their own favour and there was no longer any real chance there could be any interference with their plans. This means that while entrusted with the conduct of the affairs of the company, they deliberately designed to exclude and used their influence and position to exclude the company whose duty their first interest was to protect. Well, my lords, you can see that even if, let's say, there was a joint order against them, you can see this could fall into that category of exception, where they've all conspired together, they all appear to have received the money assumed together, and therefore the court says, well, you must cough up on a joint and several liability basis. But that's only a possible explanation. But again, I submit it's a million miles away from this type of case. It might fit into the Grimaldi category of acting in concert and dishonest and so forth as a potential explanation, no more than that. And then there's CMS Dolphin, and yet again this was a case of spectacularly bad conduct. At 2750 is where you can see the head note. I don't think my learned friend took him the head note, but if it's not a very long head note, but you get the flavour of it from the head note. And it's not very surprising that Mr. Justice Collins made the order he did. Very difficult to see how he would have come up with any different result. But if you read the facts of the head note, my lords, just briefly to yourselves, Essentially, it's the same old story. He poaches all the staff, takes the business away, doesn't let his former business associate know what's going on, sets up business and takes all the money for himself. And eventually he puts the opportunity or the business into a partnership called the Blue Partnership, which one assumes is indeed a partnership rather than a sole trading entity. But he's made to account for the entirety of the profits. Can I just ask you to go, please, to page 2774, para 100. Mr. Justice Lawrence Collins deals with the Cook and Deeks point, and then he deals with a few other cases, and then dropping down to 103. So he relies on Cook and Deeks, his interpretation being that there was a joint order there. Then paragraph 103 is the position different where, as here, the corporate vehicle generally carries on business and has real premises and staff. Even in such a case, it's possible that piercing corporate veil may be appropriate if the company was incorporated to perpetrate what must be regarded as wrongdoing close to fraud. Don't think it's necessary to resort to that. And then, since in Cook and Deeks the directors were held all equally liable, so he founds his decision on that, which I submit is perhaps not right. Then 104, nor in my judgment does it make any difference whether the business is taken up by the corporate vehicle directly or first taken up by the directors, then transferred to a company. Imperial Mercantile Credit and Deeks show that directly replaces the benefit of business opportunity in partnership with a company will be liable for the whole profit, and also make it clear the director who is the active agent breach of fiduciary duty cannot evade responsibility by transferring the benefit to others. And as I submit, again, it may be right that the result may be right, but to say that this was a result where an account of profits itself was the proper order, as opposed to equitable compensation, assessed by reference to the profits made, is a different matter. Paragraph 131 at 2781. Perhaps it's the simplest summary. If I can just ask you to read that.
131.
131. 2781, 131. Now, I submit there's nothing surprising in this. I mean, supposing I do rob the bank, take £500,000 out of it, and then give £250,000 to my brother 2 days later, you might reasonably say, well, you've got to pay the £500,000 back. The fact you've given away £250,000 to your brother is neither here nor there. So I respectfully submit one can always see that there may well be a reason why these judgments came up with the judgments they did. But it's dangerous to say they support the proposition that where A has never had any opportunity of receiving the money paid to B, and it's been perfectly properly paid to B, then that A should be liable to pay that money to B, so by way of an account of profits. It's as simple as that. And here, of course, there's no suggestion there was any impropriety, impropriety in the sense of conscious wrongdoing by either of the Ahmeds in the way they conducted the company, so as to enable the company to make profits. My Lords, the relevant references in Mr. Justice Lewison's judgment, which analyse these cases in ultraframe, it's a pretty long judgment. It begins at 1629, but the relevant paragraphs are at 1664 to 1665, and they are paragraphs 1575 to 1576, where Mr. Justice Lewis...
Repeat the paragraphs, please.
Sorry?
Just repeat the paragraph.
1575 to 1576.
Thank you.
Sorry, the page numbers.
Oh,
Sorry.
Yeah.
1664 to 1665 are the relevant page numbers,
Yeah.
but 1575 to 1576 the paragraphs.
Beats even Mr. Justice Finn's judgment for length.
I say nothing. My lord, the other case my learned friend relies on is Canada Safeway and Thompson, the Canadian case, which we deal with in our case at paragraphs 55 to 57. It's, I think, at 189 of the key bundle or 306 of the core bundle. But again, this was yet another case of deliberate conspiracy by a number of wrongdoers to divert an opportunity from the plaintiff company. And, my lords, I don't propose to take up more time on that. It's yet another example of directors putting their heads together to divert business opportunities away from the company to which they owe a fiduciary duty. And in that case, I do accept the judge expressly, Mr. Justice Manson does expressly direct a joint and several account of profits. But we say that shouldn't be followed for the reasons that I've already explained, but we say even if it is right, it doesn't have any impact on the facts of this type of case. Another point made by my learned friend is that there's an opportunity in equity, in the case of an account, for there to be a contribution under the 1978 Act. We say that's simply hopeless. The 1978 Act applies to compensation, where people have suffered the same damage. But there's no damage at all. If you elect to account for profits, you are not electing, you are specifically not electing damages, you are simply electing to have another party's profits. And we set out our reasoning in some detail at page 191, paragraphs 61 to 65 of our case, or in the core bundle 308. So I submit my learned friend can't get round, so to speak, the difficulties his submission gives rise to by reference to contribution arguments. My lord, if I can now come to the point about debt. My lords, I submit Mr. O'Brien rightly accepts that there's a considerable technical difficulty in his case, namely that a loan is a loan, and at the moment the loan was granted, it was a loan, there was a receipt of money. I should say it was not just one loan, but it was loans over a period of time. But there was a receipt of money matched by a liability to account to repay that money. That's not a profit on any view whatsoever. And this, the judge appears to have treated this matter as if it was some sort of tracing claim. But in my submission, that's wrong. A loan, once a loan, is a loan. There was no suggestion this loan was somehow a disguised profit. One could easily see if that was the case, that it might be different. But this was a straightforward loan. There was no cross-examination to the effect that it was not made in good faith. It was also recorded, of course, in all the company's accounts. My learned friend also accepts that, as bona vacantia, the debt still exists. In my submission, that's an end of it. His argument around that is to say, well, it's likely in real life that the loan will not be pursued, which I respectfully submit that makes absolutely no difference to its quality as a loan. There is still a matching liability. That's the first argument. But the second argument is this. Forgiveness of debt, let's say, in these circumstances, let's say there had been express forgiveness by the administrators or whatever, let's say there had been, that would not convert what was a loan into a profit. And causation is important in relation to accounts of profits. And for that general principle, I can ask you, I think it's the Celanese case at 1281, 36 to 37, that remoteness and those types of questions are still appropriate in cases of an account of profits. My lord, the other point I make on the debt is this. The whole finding of fact proceeded on a false basis, namely that my client, Mr. Ahmed, there was a reverse burden of proof upon him to show where the money came from, as if this was a money laundering case. Well, obviously that would be appropriate. But there's no basis here in an account of profits, least of all against someone against whom no allegation of dishonesty is made, to impose upon him the burden of where particular sums of money paid to him by the company by way of debt came from. So in my submission, the debt claim, the Court of Appeal was plainly right to come to the decision it did. I might add this. If my learned friend wanted to pursue the argument he now wants to pursue, what should have happened is he should have said, look, although the judgment, at the time the judgment was given, the debt was as it were, in existence and held by the administrators. Now, the administrators have held that the administrators said they don't want to pursue it. Now, that would require a respondent's notice with fresh evidence, at which point Mr. Ahmed no doubt would have put in fresh evidence himself, saying, no, well, if you're going to take that attitude, I want to put in my evidence in response. Namely, I repaid it. So it's not a mere technicality. If that is a point that was going to be taken against us on appeal, we had to be given the opportunity, well, there had to be a fresh evidence application, and we had to be given the opportunity to put in evidence in reply.
I can't resist the temptation. How did he repay it?
My lords, he says he repaid it. Nothing to do with bank statements. He repaid it by paying off expenses of the company. And that was the purpose of it. My lords, we can't appeal that aspect of the judge's judgment because that was a finding of fact. But that was the purpose. The purpose of getting in the administrator's report and the accountant's evidence to say it had been repaid by virtue of paying off company expenditure. It's not unusual at all. My lords, I might add this. It's a pretty odd notion that you'd expect to see a company loan to a director being repaid, so to speak, directly out of the director's personal bank account. Much more likely, on the whole, to be repaid by the director putting money into the company by way of cross loans and so forth. So, my lords, that's the position on that. I understand your lordship's question, obviously, but that, and with respect, that is Mr. Ahmed's answer, and that was the point he felt so strongly about. So, my lords, that's what we say in answer to the appeal. Can I just deal now with my reply? And on the main point, the first ground, just two starting points, but important ones. It is now accepted, as I understand it, that the case against the Ahmeds proceeds only upon the basis that they caused the company to commit the tort of infringement, and that they are not primarily liable, but liable only as accessories. Now, that is a very important point, because it means that all your lordships need to do is consider liability for accessory. What is the basis on which accessory liability in this type of case arises?
That's the many difficulties of this area of the law is there seems to be inconsistent identification of who counts as an accessory and who counts as a principal. I mean, the concepts are very confused.
They are, but I'm going to come very briefly to my submissions. I'm very conscious of time. Yeah. The second point is this. It may just have arisen because of my note, which was inaccurate for the reasons I gave this morning. But it is most certainly not accepted that the Ahmeds knew of the conflict, or a conflict with Lifestyles marks, as at 2012. Of course, what can be said is they knew of Lifestyles' opposition in 2012 to their application for a mark. But that's it, and there was no finding of anything other than, well, not even a finding of that, but there was no finding that there were, quote, a conflict or anything like that.
But there was a finding in relation to incidents of confusion.
There was a finding of actual confusion.
Yes.
But there was no finding that they knew of it, and no finding of any, that they knew of any complaints. That may not matter so much, but there was nothing. The findings, in my respectful submission, if I can give you the references, Court of Appeal accepts that it can't be said my clients were on constructive notice, and that's at 357, para 62. And the judge's finding at the first trial is at 512, paragraph 50, where he says there's no suggestion that they should have realised that there was anything wrong with what they were doing. Therefore, I submit it is very important that you cannot proceed in this case on the basis that they had constructive knowledge that what they were doing was likely to cause an infringement. You cannot proceed on that basis at all. My Lords, I've set out my test in writing as amended orally this morning. It is substantially the same test as the Mentmore and the Australian authorities and the White Horse case, in which I specifically rely on alternative. Now, what I say is this. Mr. St. Quintin has not been able to show you anything in England and Wales, or indeed in the wider common law world, where, after full argument on this point at a trial, the court has nonetheless held a director or employee an accessory as jointly liable with the company in circumstances such as this. There's not a single case that goes that way, not one. And I submit this. Whatever the position is in relation to other types of organisations, for instance, partnerships and so forth, the court should follow the Canadian and Australian authorities, which have considered the point against the facts and after argument, on this basis that in a company Where a director is said to incur accessory liability, but he's simply acting in accordance with his duties to the company without notice, it cannot properly be said that there is any jointness between him and the company. That is the underlying point. He and the company are not acting jointly if he is acting simply as the company in good faith, without notice and reasonably.
How does that work out with an employee?
The same, because the employee is acting in accordance with his duty to the company and so forth. In other words, the same principle, I say, applies to both.
The employee would be acting with somebody higher up the chain in the company, another human being in the company.
Yes, but he would be acting on the instructions of that other person. In other words, I say all those. It cannot be said that any individual who is acting within the company is himself in a joint enterprise with the company. If he's acting in accordance with his duties.
To companies and excluding partnerships, unincorporated associations?
For the moment, yes. For the moment, the reason I say that is because of the conceptual difficulty of saying that A, who is, let's say, a director of a company, is acting in a joint enterprise with the company when the company is, there's no other human being involved. He is acting as the company at that point. And that's the difference.
At the moment, this is all about joint enterprise. At the moment, you're not talking about procuring?
I was going to say something about that.
Right.
But that obviously is joint enterprise. This is my next line. What about procure? Well, in my submission, you've got to be very careful with this notion of procuring. It cannot possibly run on the basis that the director or the employee is the principal and the company the agent. Ex hypothesi, where the director or the employee is acting in good faith, they are merely agents of the company. So the analysis of procurement on the basis that I, for my benefit, get Mr. Sykes to do something for me, I procure Mr. Sykes to go and take your car, that doesn't apply. So in other words, the traditional analysis of procuring, A gets B to do something as his agent, that doesn't apply. So that traditional analysis of procuring cannot apply in company law, where directors are acting properly on behalf of the company. They are mere agents. If you start from that proposition, they're mere agents. On the face of it, they are not. The traditional analysis of procuring doesn't apply. They are not using the company to do something for their benefit. On the contrary, they're acting for the company. Now, there may be, of course, one can imagine cases, you might say, well, Mr. Knox, is a little bit technical, isn't it? But if one is left simply with this proposition, that there has to be, the director is getting the company to do something, well, one still has the notion there are two minds have to be involved. And to say that I'm procuring my company to do something when all I'm doing is actually on behalf of the company and through the company doing it, is a bit odd to say I'm procuring the company to do it, because again, there are no two separate minds involved. I'm just doing it through the company. So the procuring argument runs into the same problem as the common design argument. Procuring argument necessarily depends, in my submission, upon there being two actors. It cannot just, so to speak, depend, save in the case which I've given, where the director actually is using the company as a vehicle for his own benefit. Well, one can see that. But that's not the position here.
If you approach it from the point of view of an agent, then why do you limit it to companies? Why isn't it an innocent agent not acting in personal capacity?
I'd be very happy to do that, my lords.
But you seem to be limiting it to companies on the basis that a company cannot act by its alter ego.
Yes, well, in one sense, they're one and the same. That's right. That's the reason I say there is a difference in any event. But, my lords, if you ask me to go further, then of course I'd be more than happy to go further. I say it's monstrous that an employee in this position, even a senior executive employee, obeying orders, I know that's got a bad pedigree, but basically he's doing his best, and honestly, it's difficult. In this case, I've got a limited time, the problem goes back to a decision of Lord Ellenborough, which we refer to in our written case, where basically, I think a clerk sent on, from recollection, sent on some goods to his principal in America. And Mr. Justice LeBlanc gave a direction to the jury saying, well, if you think he was just sort of doing what he had to and acting as a clerk, then he's not liable in conversion. And then the case goes to appeal, where Lord Ellenborough sits with Mr. Justice LeBlanc, who, needless to say, sees the error of his ways, and Lord Ellenborough gives a really stinging judgment, basically saying, if the servant is ordered by the master to go on to another, what turns out to be another person's land, there's absolutely no way the servant could have known it was another person's land. Nothing the servant could have done about it. Bad luck.
But he is a primary tortfeasor.
That's right. That's the point there, yes. Now, in partnerships, of course, you could have an analysis that the partner's always going to be liable, inevitably, but you could say the managing agent, who's not a partner, this principle could apply to him. The difficulty is this particular issue is not before you, but I submit there wouldn't be any reason in principle why it couldn't apply, but that might involve some inroad to what is generally understood
Why not an
in
employee?
relation to partners.
Why not an employee of the partnership?
Oh, well, I agree. The same would happen in an employee of the partnership. My lords, I'm not saying that other people should be excluded from this rule. I'm just saying that whatever the position of other entities, it must apply in the case of companies, because there is this, what you might call, analytical point, which supports it in any event.
Can I just
Yes, of course.
You finish your sentence. What I was going to ask you is this. In a normal case of trademark infringement, of an innocent infringement, the company's activities may be carried on by a whole range of different individuals. There'll be people who buy the goods, there'll be people who sanction the mark, there'll be people who carry them to the market, there'll be people who sell them.
Yes.
And all of that is part of an enterprise carried on by the company.
Yes.
And the company will be liable for infringement.
Absolutely, yes.
Now, if somebody outside the company procures that activity, encourages the company to engage in that activity, then that person outside the company will be liable.
Yes.
Now, the question is, what is different if that person is a director of the company? And I think your answer is, they are simply the alter ego of the company for that purpose. And is that what it comes down to?
So, the internal organs. Internal organs, yes. I say internal organs. They are the organs through which the company acts. It's the phrase. Sorry.
It needn't be an organ. It could be a person.
A person, yes, but they're the internal people within the company.
Within the company.
It's the people within the company who are protected by this.
If the person is outside the company and procures it, they would be liable. But if it's a director
Or employee.
or employee who puts this scheme together, then because they are a director and on your submission acting honestly and in fulfillment of their duties, they can't be liable because they are simply acting as another aspect of the company.
Yeah. I mean, you could imagine some managing consultant comes in and says, what you should be doing is this. And then the company says, that sounds a good idea to me, and they make reasonable inquiries. But it may be the case in those circumstances if the managing consultant does not merely give advice, but, so to speak, involves himself so much in the execution.
It could be procurement, it could be a common design.
Exactly. Yeah.
But you say if that person is a director or an employee acting honestly, then that's the end of the matter, even though the company is liable.
Even though the company is liable. Oh, no two ways about that. Absolutely.
The external person equally as innocent as the internal person.
Well, no,
the
not
external
necessarily.
person is liable, the internal person isn't.
Yes, but it may be the external person. One could properly say there are two actors here. There is the external person who is not a member of the company, not a director, not an employee, not part of the company's own internal organs. He is causing the company to do these things.
And when you say the company, in the example of the external person, there's actually another human being involved.
Of course, yes.
You've got the external consultant who suggests to the chief executive that the company might do X. And I think on your example, probably, is this right? You'd say, well, if X is an infringement, then the company certainly is liable for infringement.
Yes.
And the external person is liable because he, if it is a he, has encouraged the company, acting by its chief executive, to infringe. But you'd say the chief executive is the alter ego of the company, isn't personally liable.
Yep.
Is that the analysis?
Well, the encouragement wouldn't be enough. Procured. They would have to go
Sure,
first.
I appreciate that. It's quite a difficult concept with a consultant, I suppose.
Yes.
Yes.
But that person, just picking up Lord Stephen's question, which I don't think you've answered with respectfully, is that innocence for that external person would not be an answer if it is a strict liability tort.
No, not on the face of it, no. My lords, although I don't say he wouldn't be liable, I just say I don't go that far, but if I have to go that far, I say, well, I can go that far, but I limit for the moment the principle to people within the company, as opposed to people externally, because externally there would at least then be a jointness, a relevant jointness.
Mr. Knox, you're
I know.
out of time now, I'm afraid. We need you to bring your submissions to.
Yes, my lord, can I in that case go very briefly, first on Professor Flanagan's article, a wonderful polemic, but he's got no, his analysis aside, but runs into the problem identified by my Lord Legate this morning. It's not that easy to explain away the infringement points. As far as Sprite Brand is concerned, I just want to say this. Lord Justice, first as a tentative authority, and Lord Justice Slade was very troubled by one particular point, namely there was an express defence in the Copyright Act of acting reasonably and without knowledge and so on and so forth. And the director was trying not to take advantage of that defence, but to get the claim kicked out without having to run that defence, where the burden would be on him. And I can see there may be differences in cases where there's a specific defence provided for by statute, which necessarily cuts down the ambit of any other defence you might have as a matter of law. And as far as, I don't think my learned friend took it to Charlie Records. We just adopt everything we say in Charlie Records, and likewise Sprite Brand. We give a fairly detailed analysis of Sprite Brand. As far as Ottercroft is concerned, that was on the burden of proof point. That's a different case. That's, again, a case of a director behaving badly and without his co-director's knowledge. And you can well see in those circumstances that if he's going to run the argument, I was acting in accordance with my duties and so forth, it was impossible for him to do so because he acted in breach of an undertaking, dishonestly, and without his co-director's knowledge. It was a hopeless submission. So I respectfully submit Ottercroft doesn't help you. For your reference, it's 1558-6/8, 1560-13, and in particular 1563-2021. That doesn't help you. As far as there's a case called Hashtags goes, an Australian case. In my submission, can I just ask you, this is another case of the directors behaving very badly. The relevant references in the bundle are 2071, paragraphs 96 to 100, and 2075, paragraph 109. And also, page 279, there was an express finding, which they couldn't overturn, that they used the company as their alter ego. So that's that. As far as the account point is concerned, my Lord Richard mentioned the point of Keach and Sanford. I didn't have the wit to answer. Of course, that's right, but we're here dealing with accessory liability. And that is where the answer, because of course in a trust case, if someone is accused of assisting in a breach of trust, you've actually got to show dishonesty. Now, I'm not saying that necessarily applies in relation to an account here, but it does go into the mix in my submission. If there is innocence, as we say there is, as an accessory, even if you're liable for the tort, we say that is obviously a relevant factor. And we've taken you to the references about acting innocently. And in particular, we say, in relation to the point on salaries, there's no unconscionability of retention of a salary earned in good faith over the years, whichever way you cut it. And the basis of an account is unjust enrichment. That's the justification. But if there's no unjust enrichment, if you hold on to the money, then in my submission, the basis for an account goes away. My learned friend says there was no error in the Court of Appeal. One error which he couldn't get around is the Court of Appeal did not take into account that there was no allegation even that my clients had acted unreasonably. That is an important point.
Mr. Knox, just before you sit down,
Yes.
certainly for my part, I was very grateful overnight to be supplied with a transcript of the submissions. Are we going to be afforded the same benefit in relation to today's submissions?
Oh, I didn't realise you had a transcript.
I guess the transcriber could keep up with your speed of delivery, actually.
I'm sorry, my lord.
Thank you, Mr.
Well, that's a miracle.
I think
My lords, those are my submissions.
Yes, thank you very much.
My Lords, for my part, I just have two brief points of clarification in response on ground one of Lifestyle's appeal. The first relates to the House of Spring Gardens case. The second, and they both brief points to the treatment of Regal, Hastings and Gulliver in Mr Justice Lewison's judgment in Ultraframe. In respect to the House of Spring Gardens case, my Lord, my learned friend suggested that it was a factor in Mr Justice Costello's decision that there'd been atrocious behaviour on the part of the defendants in that case. In my submission, that's incorrect. Plainly, there was finding of bad behaviour by those defendants in that case, but it's also quite plain that that was no part of the factors that Mr Justice Costello took into account in making or reaching that conclusion. The only factor that he took into account in ordering the account to be joint and several was that they were liable jointly for the same tortious act. And that, you see that in the quote. Both the characterised as atrocious behaviour and the finding that I rely on in respect of the joint account are all on page 3256 of the large bundle. The atrocious behaviour is in respect of a different matter. The other point, it was suggested by my learned friend that in Mr Justice Lewison's judgment, he had held the relevant principle that came from Regal and Gulliver, was that Mr Gulliver was not liable for the profits of his co-directors. And in my submission, there's no support for that in Mr Justice Lewison's judgment. What he said expressly, it's a two-line paragraph at paragraph 1555, page 1657, is that he wasn't liable for profits that he had not made. It's quite a different point in my submission. And as I submitted earlier, isn't, in fact, a relevant finding on that judgment. The judgment simply found he wasn't liable, rather than that he wasn't liable to provide relief. So, my lords, unless I can assist you further, those are my points in response. Mr Brown may have some short points as well.
Anything further? Right, Mr Brown.
My lords, just page references arising out of some of your lordships' questions of my learned friend to assist your lordships in composition of the judgment. Page 360, big bundle, paragraph 85, this is where the Court of Appeal records how the tax point emerged for the first time in the Court of Appeal. I accept, for the sake of assisting your lordships, that tax was mentioned in the pleading, and that's at page 489, paragraph 24E, and your lordships might want to read it to see how it's mentioned. In relation to some questions asked by my Lord Stevens of my learned friend Lauren Sykes, KC, at page 338, my Lord, you will find the order for the payment of the revised sums is stayed by the Court of Appeal. That, as I understand it, was on the defendant's application, as one might expect. The next page reference relates to a question asked by my Lord Stevens and my Lord Richards. At page 401 to 404, your lordships will find the judge's judgment on the defendant's application, in which they deployed that administrator's report in relation to the non-pursuit by the administrators of Mr. Ahmed. And my Lord Richards, you will see Lifestyle's position reflected in the terms of that judgment. And slight apology an apology from me in relation to a page reference I gave earlier. It was where Lewin deals with the incidence of taxation in relation to accounts of profits. Under the title, the incidence of taxation is ignored. The excerpt starts on page 99, as I said, but the relevant passages are on page 101.
Sorry, so this is, just give me the reference again.
And forgive me, that's in the...
Oh, it's in the
supplemental bundle.
Sorry, can I just see what we're talking about? It's on page 101.
Exactly, and it's, to give the paragraph references again, 41-022
yes.
to 41-023. 23. And again, for the sake of assisting your lordships, I accept and agree with my learned friend Lawrence Sykes KC that the issue is one, if I may say so, of policy, which is binary if your lordships to decide, given the way the parties have put their cases.
Can you explain the calculation on page 701 or not?
No.
Right.
On the question of the loan, the respondent's notice point was mentioned. Again, to assist your lordships, I consider it to be technically correct to say that a respondent's notice ought to have been put in to rely upon the administrator's report or the fact of dissolution. My learned friend Tom St Quintin, in his written skeleton argument for the appeal, referred to dissolution and the non-pursuit by the administrators. That's at paragraph 64 on page 627. It won't be controversial for me to say that there was no objection in the Court of Appeal based on the absence of a respondent's notice. Finally, and I think this probably goes beyond a page reference into the territory of correction, my learned friend Peter Knox KC referred to the point that I made, attempting to refer to the real world, where I said that there would be no payment of the Crown of the monies outstanding technically to the Crown on the loan. My learned friend suggested that in response, Mr. Ahmed could put in evidence to show that the loan had been repaid, and that prompted a question from Lord Stevens. My learned friend properly accepted that he couldn't challenge the factual finding that on the evidence put before the court, the loan hadn't been repaid, and there was a finding to that effect. That finding is it.
He certainly could challenge it if the Crown came after his clients. They couldn't challenge it then.
And you and I, my lord, discussed that earlier.
Yes.
The page reference I wanted to give was 399, and it's paragraph 98, which records the finding that on the evidence presented by Mr. Ahmed, the court found that the loan had not been repaid. Yeah. My lords, that is all from me, so unless I can assist further, those are our submissions.
I was wondering whether we could have Mr. Knox's version in writing.
My version
of the test.
Oh, you mean correctly?
Yes.
Corrected. Yes.
Corrected.
Yes, that'll be helpful.
Yes, I think I've got a scrawl which I should be able to interpret on my own.
Good.
Yes, and hopefully your lordships heard that the transcript will be forthcoming of today's
That's helpful. Thank you very much.
Submissions.
Well, we're very grateful to all counsel in the case. We're also very grateful to those sitting behind you for the preparation of the matter. It's clearly been a heavy and complex matter. We will take time to consider our decision. Thank you very much.